Civil Judge, Junior Division, and Law Examinations. Law of Evidence in English language. Evidence by Conspirator. Section 10 Indian Evidence Act 1872 or its corresponding Section 8 Bharatiya Saksha Adhiniyam 2023 to be effective from 1st July 2024. Dear student friends, today I wish to take up one of the most important topics from Law of Evidence, that is Section 10 Indian Evidence Act, Section 8 Bharatiya Saksha Adhiniyam. The contents of both the sections are absolutely remain unchanged. In this lecture, I wish to cover who is conspirator, what is the nature of evidence, how far the evidence of conspirator against co-conspirator, that is other conspirator or other conspirators, is admissible, in what form the evidence is can be produced, and how far it can be admitted as relevant, we have to discuss, and meaning and definition of conspiracy, liability of conspirators, the principle or general rule underlying the concept of conspiracy in criminal law, and what are the conditions to be complied with, to be fulfilled, to invoke Section 10 of the Indian Evidence Act, similarly Section 8 of the Bharatiya Saksha Adhiniyam, and finally what are the restrictions under Section 10 is the topic for discussion today. Before taking up this topic, let me take just 1 minute. I'm very glad to note that my channel has crossed more than 16,000 subscribers. It's all with the consistent cooperation, love and affection of my student friends. In this connection, I express my deep sense of gratitude and heartfelt thanks. So I sincerely and honestly promise you all to take every effort. I work hard and I refer good number of standard textbooks and internet to place before you the best contents in a comprehensive style, so as to cater the needs of students facing LLB examinations and also judicial service examination and other competitive examinations. Please note that all my lectures are in English only. A few of them are in Telugu. If the title contains within brackets in Telugu, that lecture alone is in Telugu. But when once a Telugu lecture is uploaded, immediately in a day or two, by collecting some more information, the lecture will be uploaded in English. So all these lectures are common to LLB examination and judicial service examination also. Judicial service exam doesn't mean that they are not useful for LLB examination. For earlier, I delivered lectures keeping in mind the requirement of LLB students in a simple, but of having taken up the task of uploading classes to judicial service, I have improved the standard, I have increased the length of the lecture. So the LLB students can not only LLB students but also judicial service students can make use of my lectures. There is no wrong if the teacher who is taking up new subject as fresh may follow my lecture first in video or my textbook, and then he may go to the high standard textbook of his choice and continue as a deliver lectures as a successful and eminent teacher, dear friends. So, whoever, I sincerely, honestly promise that whoever has completed watching all my lectures, provided he has enough knowledge in English, he would be able to understand English, speak English. Such students who have completed all watching all my lectures, they are sure to face any examination, competitive exam, or they will be very successful in advocate also. This is my opinion. I once again suggest my student friends to follow my watch my lecture immediately at the time of notification. Thereafter, you as and when you are free, once in a day or 2 days in 2 days, one lecture in 1 day or one lecture in 2 days. The remaining lectures, irrespective of your class, for if you are a student of first year, you just choose pick out your subjects of first year. If you find some more time, you can proceed to watch my other second year final year lectures also, with because every subject they contain, I am whatever subject is covered when while teaching first year subject evident. If CRPC covered, I'm explaining that. If CPC is covered, I'm explaining that. If IPC covered, I'm explaining that. So these lectures, particularly I have given very good number of lectures in constitutional law, administrative law, alternative dispute resolution. They are of wonderful legal knowledge. They will be helpful to you. Even though for Andhra Pradesh Judicial Service exam, the constitutional law, administrative law, and this what is called ADR is not given. So in one examination, ADR question is given. In one examination, judicial activism question is given. Essay is given. So if you watch just my channel, the summary as a whole you can write. It will serve the purpose. Dear friend, I sincerely, honestly promise you to upload each and every lecture, but please note that I will have to prepare a lot for delivering these lectures. If I will be able to teach Suyamoto, I will be in a position to teach one lecture a day. But so far as the lectures which I covered long back, some students are requesting in Telugu. It is not there is no difficulty to give. When once I translate those two Telugu English lecturer earlier into Telugu, I will cover some more information and will translate after delivering Telugu. Immediately I will translate it into English. So please note that if anybody tells anything wrong about my candidature and lecture, don't trust them. You trust me. In case you get disappointed, you accuse me and even abuse me, I welcome it. I welcome your adverse comments. Don't think otherwise. As a matter of fact, I wanted to deliver two lectures, two topics, that is section 10 conspiracy, and section 11 LB, both I prepared. If I do it, it will take more than 2 hours. That is why I try to confine the lecture as far as possible to 1 hour. So don't think that, don't make adverse comments that up to 10 years he spoke gas, after 10 minutes only real class start. Some students are hurting my feelings, dear friends, because as a mad token of respect and gratitude to my student friend who are solely instrumental for what I am now, I wanted to show my gratitude. My service is absolutely free and service made. I never expect even single pie from you. One more thing, dear friend, so many student friends are requesting me to give PDF, but I am alone here in Pune. I don't have any assistance. I won't be able to upload it into PDF. I requested my publishers to bring out those small books, which may be within less than 100 pages. I'll be able to release one book as a simple capsules, but publishers are not coming forward, because if the books of below 100 pages are relieved by me, the other my books we earlier published containing more than 300 pages, 400 pages may not be sold. So they have their own personal inconvenience for which I cannot press them. If you are really interested, if you eagerly need my guided my PDF, so I'll be able to do one help, dear friend. After you first I deliver lecture in Telugu, thereafter in a day or two I will deliver lecture in English, same topic. In the next day I will prepare a beautiful notes covering variety of points. I will read out, I will give dictation. Will in heading conspiracy, dictation will be there. When dictation means absolutely English, there is no question of Telugu. If you can, if you upload that lecture, you take earphone, take notebook and write. I read out very slowly. If this proposal is accepted by all of you, if you welcome it, I will make it each and every lecture one topic. First Telugu, in a day or two in English, in the next day reading out is very easy. There is no any problem. So whatever time is required for delivering lecture, absolutely same time is required for PDF also. When once you upload it, you suppose words are missing, you can revive it. You can revive it and you can put it, touch it to back and can be continued. Okay, thank you very much, dear friend. In this lecture, I will take up a conspiracy. So, dear friends, just a matter of just token of for the purpose of introduction only, let me tell you two sentences. Crime is a social phenomenon. Garofalo, a distinguished criminologist, said crime is a social phenomenon. It varies from place to place, time to time, and situation to situation. That is, situation is important to connect this point. Place to place means what is crime in India may not be a crime in America. For example, adultery is a crime in India. Adultery is not crime in America. Place to place. Suppose some time back there was a prohibition of consumption of alcoholic drinks in some states. Subsequently, the ban was lifted. So today, for example, consumption of alcoholic drinks is illegal. Suppose some new government will come in a particular state. The new state government passes legislation abolishing the consumption of alcoholic drinks. It is law. So time to time law may be changed. Similarly, we are finding so many amendment acts to so many things. We are deleting old points and old rules and inducting new rules. That is time to time. And situation to situation. Suppose an accident is absolutely inevitable accident like act of God accident. It is the person is totally exempted from liability under Section 80. Suppose it is a negligent accident, it is attracted under Section 304A. The negligent driver is liable for imprisonment up to 3 years. Suppose he intentionally committed an accident with an intention to kill that person. Intentionally, recently one judge was for giving for not giving judgment in favor against favor, that is conviction, that judge was dashed and killed. That is intentional accident. It amounts to culpable homicide or murder. So like this, so situation to situation. Like that, the crime generally takes place in a clandestine way. Clandestine way in the sense secret place. It may be committed sometimes crime is committed by one person, sometimes crime is committed by two or more persons. Two or more person. If crime is committed by this section refers to conspiracy, that is criminal law. You please note. So most of the provisions in Indian Evidence Act or Bharatiya Sakshya Adhiniyam, some provisions are related to both civil law and criminal law. Some provisions are exclusively related to criminal law. Some provisions are exclusively related to criminal law. For example, admission section 17 to 23 and 31 relate to civil litigation or civil proceeding. Section 24 to 30 30 of Indian Evidence Act relate to criminal law. So what are these corresponding sections in Bharatiya Saksha Adhiniyam? I will take up in admissions and confessions chapter shortly. So, dear friend, don't think that I am delivering lectures slowly. You make use of the other lectures. You watch those lectures in earphone and put the side heading and write as the basically the prima facie basic requirement for all of you is you must be able to speak English. You must be able to understand English. You must be able to write very clearly. You have to mention so many side headings. That is very important. But in some states, the local language is allowed. There is no problem. If local language is not allowed, so then it is mandatory to learn English. You have to spare some special time, devote some time and start speaking English, right or wrong. For LLB examinations, wrong English is negligible. For competitive exams, wrong English will be strictly taken into account. So, dear friends, now coming to the see. So here, crime takes place in a secret place. So that is why sometimes one person alone commit crime. Some A wants to kill B. He will prepare, he will go to B's house and kill him by stabbing or shooting or any other purpose. Then A alone is liable. A alone is liable. Sometimes what happens is A is some rich man or some timid man, coward. He cannot go and kill it. Then he will engage somebody. Some rowdy shooter or somebody. Then A engages B to kill C. Suppose A wants to kill B. He engages C. Then A is abettor, C is principal or wrongdoer, B is deceased victim. So in such case, abettor in criminal law, if this principal wrongdoer C is caught by police, he will tell the name of A sometimes. Suo moto he may tell when interrogation due to unbearable pains inflicted by the police to find out the truth. C may disclose that A engaged me to kill C, like that. Then A is abettor, C is the principal wrongdoer. Both A and C are equally liable, equally will get same punishment. That is the liability is constructive. So sometimes what happens is two or more persons mutually express their intention. Suppose A wants to kill B, then A approaches C, or when C meets A expresses his willingness or inclination to kill B. When A expressed his intention or inclination to kill B, because so long as B is alive, I won't be able to win the election. So I have to put an end to B's life. Then only I can win the election. That is the thing. A expressed his intention. Okay, I will help you. I too will join you. And immediately the expression of intention is communicated and it is acknowledged and first accepted by C. Then that intention becomes a common intention. If the A and B are both or one of them act in accordance with that is with reference to common intention or in accordance with the common intention. When that is what is called conspiracy. These two persons are called conspirators. Sometimes two person, sometimes two or more persons may join together and to commit a crime. It may be theft, it may be a robbery. Theft means locked house breaking and taking property, that is theft. If people are inside knocking the doors, pointing revolvers and deadly weapons, extracting money, that is robbery. Dacoity, for five group of people like Sholay attack the people and take away, that is dacoity. All these things I explained in criminal law, theft, robbery, dacoity, extortion, all these things I told you, dear friends. So this is the position. Now, if two or more persons, now what do you mean by if two or more persons mutually agree to commit a crime, they are called, that process is called conspiracy. They are called conspirators. This point is over. Now, meaning. What is the meaning of conspiracy? The word conspiracy literally means breathing together. Inhaling, inspiration, expiration equal to respiration. Conspiracy means three. What is there in my mind, it is also there in mind. These two minds come together, that is what is called intention. That intention of both the person is there, but that both the intentions are united, then it becomes a common intention. Suppose A is there, A wants to kill B, but he is thinking whether I should alone kill him or I take the help of somebody. Then he calls C. Now I want to kill A. I want to kill B. A tells C, I want to kill B. Okay, I too cooperate you. Let us kill him. And B also joins. At the time of scene of the offense, whether A may kill or B may kill, C may kill B. But what is whoever may kill, but both are equally. One enters inside and kill B, and C stands outside to watch anybody is passing through that way. But the share is equal. Irrespective of their share in commission of the crime, they are equally liable. In criminal law, the liability is joint and constructive. Whatever punishment is given, the same punishment is given to all. Life imprisonment means both A and C are given life imprisonment. Death sentence, both are given. So this is breathing. So conspiracy is a secret planning. Conspiracy is a secret planning to commit an offense. So that is what is called. This is the meaning of conspiracy. Now, conspiracy definition. Chapter 5A containing section 120A and 120B of Indian Evidence Act defines section 120A of Indian Evidence Act, part 5A of Indian Penal Code. Part 5A of Indian Penal Code contains two sections. They are section 120A and 120B. Section 120A defines criminal conspiracy. Section 120B prescribes punishment for criminal conspiracy. Depending upon the nature of the conspiracy, the punishment is prescribed. Now, according to Indian Penal Code section 120A, section 120A defines criminal conspiracy as when two or more persons agree to do or cause to do an illegal act or an act which is not illegal. By illegal means such an agreement is designated as criminal conspiracy. According to section 120A of Indian Penal Code defines criminal conspiracy as when two or more persons agree to commit an illegal act or an act which is not illegal. By illegal means that agreement is designated as criminal conspiracy. Simply speaking, when two or more persons enter into an agreement enter into an agreement or come together and agreed to do or commit a crime, that is an illegal act or legal act by illegal means. Simply, commission of when two or more persons agree to commit an illegal act or legal act by illegal means. Illegal means murder, rape, theft, all corruption, all are illegal. Legal act by illegal means an act which is not illegal means not unlawful or immoral. But it by illegal means suppose arranging a medical seat in wrong route, ignoring the merit student. Okay, suppose medical seat is some for 1 crore rupees, for example, and then somebody the who seeks medical seat will conspire with somebody in entrance examination of medical exam, and I will offer you 20 lakhs, you give medical seat to my son, or like that. That is called procuring medical seat is not illegal, but it is the legal one, but it is acquiring in illegal means. So acquiring qualifications in illegal means, like that. So agreement to commit an illegal act or legal act by illegal means according to this. So next, one more definition given by Stephen, one of the distinguished jurists, defined conspiracy when two or more persons agree to commit any crime. When two or more persons agree to commit any crime, they are guilty of conspiracy. When two or more persons agree to commit any crime, they are guilty of conspiracy, whether the crime was committed or not. So according to Stephen, what is this? When two or more persons agreed to enter into an agreement to commit crime or agreed to commit crime, they are guilty of conspirator. They are guilty of conspiracy. They are called conspirators. Whether the offense is completed or committed or not. So in commission of crime, I told you there are 4 stages in commission of crime. One is intention, second is preparation, third is attempt, fourth is accomplishment. Intention, A in his mind thinks that I have to kill B. That is, he is speaking in his mind. That is intention. Preparation, he purchased some poisonous bottle, or he purchased a revolver, or he purchased a sharp-edged knife. That is the preparation. Attempt, he goes to A goes to B's house and opens fire, but the bullet was missing. That is attempt. Suppose if the bullet hits B, that is accomplishment. So there are 4 stages in commission of crime: intention, preparation. So preparation and intention cannot be detected, but attempt is visible, and intention is mental fact, psychological fact. It cannot be detected so easily. Preparation may be sometimes ascertained, sometimes may not be ascertained. If it is preparation is done in secret place. The attempt is physical. If was death attempt is missed, that is attempt. Fourth one, if the bullet hits the body and that person dies, it is called accomplishment. So that is why, according to Stephen, if whether even if his attempt is made, according to section 511 of Indian Penal Code, attempt is punishable. What is the punishment for murder? Attempt to murder also is punishable equally. So that is what is called this thing. And one more definition is the Supreme Court in Bhagwant Swarup. The Supreme Court also has defined criminal conspiracy in one case. The Supreme Court in Bhagwant Swarup versus State of Maharashtra defined conspiracy when two or more corrupt persons, agreeing together to do by concerted action something unlawful, either as a mean or by end. This is the definition. The Supreme Court in Bhagwant Swaroop versus State of Maharashtra defined the term conspiracy as two or more persons. Two persons are more than two corrupt persons. Corrupt persons means wrong-minded person, illegal-minded persons, corrupt persons. A right man satisfies with salary. Corrupt man wants more and more money apart from salary. To do any job, he receives extra money, then only he will do it. That person is called corrupt person. When two or more corrupt persons agreeing together to do a concerted action. Action means an action done by mutual concession, mutual discussion. That is called concerted action. By mutual consent, some action has been taken. Concerted action to concerted action. Something unlawful or illegal. Something illegal. Either as a mean or by end. Either by means or by ends, whatever it may be. Two corrupt minded persons agree together mutually by concerted action to do an unlawful act either by mean or by end. That is the definition of conspiracy given by the this thing. So in conspiracy, if two or more persons enter into an agreement to commit crime with common intention, and the crime is committed in accordance with that common intention, that activity, that process is called criminal conspiracy. The persons are called conspirators. Conspirators mean co-criminals, partners of the crime. Now, what is the liability of a conspirator? In criminal conspiracy, all conspirators are in criminal conspiracy, all conspirators are equally liable. All conspirators are equally liable. Equally, suppose two or more persons, three persons, A, B, C, went to D's house to kill him. A stands at the gate of the D's house. B and C enter into the house. B ties hands and legs of D, and C takes knife and kills him. That is, here the main C killed D with his own hand with knife. B tied the hands and legs or caught his hands and legs that he should not move or he should not escape. So when D tried to escape, B caught him and tied his hands and legs. Then C killed him. But A was simply waiting outside to give signs if anybody is walking on that road. So here the degree of participation is different. Yes, participation is something, and B's participation in tying legs is something more. C's participation in killing is something more. So that is why, even though their share in commission of the crime are different, more or less, once they are caught, they are given equal punishment. In that process, all have absconded, only C is caught. Then C may reveal the name of A and B. Then suyomoto he may reveal the name of B, thinking that why three of us committed this crime, why I alone should be punished, let them also be punished along with me. With that intention also, C gives evidence in court, who caught by police gives evidence in court about A and B. That is there. So sometimes if he doesn't reveal, the police may in interrogation may beat him, and lie detectors and all technical processes, he may reveal the names. Then whatever evidence is given by one conspirator against the other conspirator is relevant. In that process, words, things done, whatever things they have done, acts done, words spoken, and words written, any documentary evidence. It is in manuscript, it may be in it may be in a manuscript, it may be some fingerprints prints like that, it may be in a printed form, typed form, or digital form, whatever it may be, the evidence or evidence which contains things done, acts done, words spoken, or documents produced constitute the evidence of the one conspirator against the other conspirator, that such that evidence given by one conspirator is relevant and admissible according to Section 8 of the Indian Section 10 of the Indian Evidence Act, and its corresponding section is Section 8 of Bharatiya Saksha Adhiniyam, to be effective from 1st July 2024, dear friends. So now next point for discussion is what is the basis for this joint liability or constructive liability? Why two or more persons commit crime jointly? Why they should be caught? Why for three or more persons may be there, out of them one alone killed, two others were bystanders, why all of them are killed, why all of them are to be punished? What is the principle? So this is the principle of the originated from principle of vicarious liability. Generally, the principle of vicarious liability is there in civil law, civil proceedings or civil litigation. That is, master is liable for the acts of the servant. So similarly, principal is liable for the acts of the agent. And master and servant, I told you in law of torts, and principal and agent liability, I explained it detailed it contracts too. Principal and this thing in civil litigation. Similarly, in partner, for one act of one partner, all partners are liable. For acts of all partners, other partners, one partner is liable. So one acts for all acts for one. If a driver of lorry commits accident, its owner is held liable. That is the principle of vicarious liability. Earlier it was said that the principle of vicarious liability is available in civil litigation. The principle of vicarious liability is not available in criminal law. That is. So here one tailor is there. In tailor, a button stitcher is there. Suppose a man gave his suit cloth worth 50,000. Then for stitching, that button stitching boy ran away along with that suit. So the master of the tailoring shop must pay the value of the coat. So he is not punished for 2 to 3 years imprisonment for committing the theft. So here in civil law, vicarious liability is unknown in criminal law. But there are certain exceptions in for vicarious liability. Vicarious liability is available. Vicarious liability is available in criminal law in case of abetment. So abetment means one man engages another man for commission of a crime. The person who engages is called abettor, and other person who is engaged is called principal wrongdoer. Suppose a politician who wants to contest, wants to kill his rival, then he engages one rowdy shooter or some criminal to kill other politician. So this politician is called abettor. Section 108 to 120 Indian Penal Code lay down various provisions relating to abetment. So this abetment, the abetment takes place in three ways. One is abetment by instigation, abetment by conspiracy, and abetment by intentional aiding. So conspiracy is one of the modes of abetment. So conspiracy also the criminal liability extends to criminal conspiracy. Abetment by intentional aiding, so exposing, so that man is responsible for destruction of your family. You have, your parents are killed, you have become orphan because of that man. Oh, he is responsible for all this. That is called abetment by instigation. Similarly, the son got married to poor woman and brought her as his daughter-in-law. Mother and father do not agree, but mother instigates the son. So you got married to poor girl, but you get rid of that girl, kill her or send her out, so that I can get you married with more beautiful girl and a richer girl. Then further, see, that mother is instigator. That mother is a instigator. That son who killed his wife or who sent her wife is called principal wrongdoer. Mother is called principal in the second degree. Principal in the second degree. So there are four kinds of criminal: principal wrongdoer, principal in the second degree, accessory before the fact, accessory after the fact. These things I explained in criminal law. So now coming to the next point. So like that. So this concept of conspiracy is based on the principle of agency, or principle of agency in the sense how principal is liable for the wrongs committed by the agent. The principal is like that principle of agency. It is called principle of mutual agency. Mutual agency. So in abetment, principle of agency or implied agency it will come. But whereas in conspiracy, it is based on principle of mutual agency. So A acts for B and B acts for B. So both are, the action of A is for B, the action of B is for action for the benefit of A. So it's for mutual benefit, mutual understanding. One A acts for B, B acts for A. Suppose C, A acts for B and C act for A, like that. That is what is called mutual agency. One helps to other when cooperates with other. That is why this concept of conspiracy is based on the principle of mutual agency or implied agency. Implied agency. When you engage somebody, that man commits a crime. That crime is deemed to have been committed by you. It is implied that crime is deemed to have been committed by you. That is implied. That is implied. So this is the principle of joint. This principle of joint liability. Now coming to the now conspiracy is one of the modes of abetment that is over. And next thing is now when you want to now section 10, according to section 10, when things done, acts done, acts done. I will read out the section. Relevancy. Section 10, Indian Evidence Act. Section 8, Bharatiya Sakshya. Relevancy of statement made by one conspirator against other conspirator. Evidence of one conspirator, that is statement I already told you. Evidence of one conspirator, that is statements which include acts or things done or words spoken or written or against other conspirator or conspirators are relevant and admissible in evidence under section 10 of Indian Evidence Act, subject to so according to section 10 of the Indian Evidence Act, when one conspirator gives evidence in a court of law against the other conspirator against him, the evidence contains acts done or things done or words spoken or written. The written in the sense documentary, production of documentary evidence by that particular conspirator. It may be printed, it may be typed, it may be in digital form or electronic for that evidence by one conspirator is admissible against another conspirator. That means that evidence given by one conspirator who was caught with that evidence, the other conspirator or other conspirators who against whom the confessional statement is given, they also can be arrested and brought into the clutches of the court will take cognizance of those conspirator, other conspirator against whom the statement is given. They also will be held liable along with the conspirator who is giving evidence. This subject to fulfillment of some conditions. So that is why this section 10 will read out all these points. So here section 10, the main thing is when one conspirator gives evidence by things done, acts done, words spoken, written against another conspirator, provided the condition is there must be prima facie existence of conspiracy. So the conspirator of suppose A and B are conspirator, B is caught and B is asked to give evidence. If he gives evidence against A, then only it is okay. So when B wants to give confessional statement against A, there must be prima facie evidence. There must be reasonable ground that was a conspiracy between B and A. When B wants to give evidence against A, it should be proved beyond all reasonable doubts that A has conspired with B. Both were conspired. So the other man against whom this man is giving evidence is his co-conspirator, co-accused, co-criminal, partner of the crime or accomplice. That should be proved. Prima facie evidence. Conspiracy should exist. Reasonable ground must be there. Conspiracy is there. Both are co-conspirators. That is the first thing. Second, to constitute conspiracy, some conditions are that when one person wants to commit a crime, if he himself commits the crime, it is independent crime. If he wants to take the help of another man, suppose A wants to kill B. Now he alone cannot do it. He wants the help of somebody. He approaches C and expresses his inclination. Now I want to kill B. Then C, yes, Fred, C, okay, no problem. I too will help you. Let us do it. For example, wife and husband is there. Wife is having extramarital relation with some neighbor. So whenever a husband goes to office or elsewhere, these two are involving in adulterous activity. So they are doing this they are not able to do that. Anytime husband may come. So they want to continue their sexual relationships happily. There is a relevant case is there. Sexual relationship happily. They wanted to kill husband. So this wife and her lover both agree. They mutually agree. They want to husband, lover proposes, better we kill your husband. Then okay, I do agree with you. So when once the inclination or intention was spoken out, immediately that is acknowledged, and the first intention was accepted by the other, then only. So that inclination to kill husband was proposed long back earlier. After the conspiracy is created sometime later, it is not permitted. When once the intention is there, that the intention is first entertained by the other conspirator, other person, then only it amounts to conspiracy. It constitutes conspiracy. If it was done the former intention or subsequent intention, outside preceding intention or succeeding intention, other than the existence of this intention, cannot be brought, we cannot be included within the meaning of section 10. On this point there are some relevant cases also. So this second point is second paragraph speaks about this. First paragraph speak about by constitutional statement by evidence by one conspirator against, provided there exists of conspiracy, both are conspirator. The intention is revealed and first entertained by other man, and it is subsequently entertained, and anything subsequently the intention is acknowledged, then only all the conspirators are equally responsible for commission of the crime. That is the purpose of proving the existence of conspiracy. So I am not telling you reading out the contents. You go through the Bayer Act or textbook. You may, when once you read the contents of section 10 Indian Evidence Act or section 8 Bharatiya Sakshya Adhiniyam. So since the beginning of Indian Evidence Act to today, not even a single sentence is changed from old act and new act, except the sections only, and section 2 repealing act was shifted into new act as a new chapter, that's all, dear friend. Now to invoke to invoke section 10 Indian Evidence Act or 8 Bharatiya Sakshya Adhiniyam. So to invoke section 10 means the evidence given by one conspirator against another conspirator is relevant and it should be admissible evidence. In order to say that this evidence is relevant, this should be accepted by the court. That person who wants to say that the evidence of one conspirator given against another conspirator must be accepted or entertained by the court, if he wants to tell, he should prove four conditions. Number one, there must be a reasonable ground or prima facie evidence for commission of conspiracy. So the person who is giving evidence in court of law says that I and that particular person totally committed this crime. He is my co-accused, co-criminal, and we both there. Whatever things he said, whatever acts he has done, he has said. But when once you say that whatever you say against him is right, first of all you should prove that you conspired with that man. You and that man have been entered into conspiracy. If you want to tell about two conspirators, you should say that, you should prove that yourself and two of them, three of you conspired with one another. That is more. In conspiracy, one may be intelligent man, others may be negligible persons. One is a intelligent person, others are just helping people. So when 2 or 3 or 4 persons go there, one may do 4 persons go to bank to rob the bank. One goes in this direction, other goes in direction, and when while going to bank for robbery, they come across any doubt, anything, they may do anything accidentally without telling in the absence of other man, or without telling anything to other man, spontaneously they take. Suppose when they are going, the Gorkha may attack and try to open the fire. He may open the fire and kill that Gorkha, that watchman, like that. When they are indulged in such, in Barendra Kumar case also, I told you in section 34, 149, joint criminality, this thing. That is the first point you have to do. The second thing, prima facie evidence and existence, to invoke section 10, it should be proved that there is a reasonable ground that there was existence of conspiracy. Secondly, there is a prima facie evidence that there is a conspiracy, they are conspirators. Second point is so when once conspiracy is given, the evidence, the statement by one conspirator is against the other conspirators. So here one but the person who is giving evidence is conspirator, and the person against whom the conspiracy is giving other is the conspirator. So when he wants to give evidence, the evidence must be against him, not a favor to him. Favor to him. Both must be the conspirators. So according to Section 133 of Indian Evidence Act, according to Section 133 of Indian Evidence Act 1872, Section 138 of Bharatiya Sakshya Adhiniyam, same contents. In Evidence Act 133, Bharatiya Sakshya Adhiniyam 138. So when one conspirator wants to give evidence, that evidence, this man and that man must be conspirators, that is partners of the crime, that is accomplice witness, evidence given by accomplice and partner of the crime. Two or more persons commit crime, one person is caught. If he gives evidence that I alone did not commit that crime, there are two others also, three others also, are the three others also are the co-criminals, co-conspirators or accomplices. According to Section 133 of Indian Evidence Act and 138 of Bharatiya Sakshya Adhiniyam, the one evidence by one conspirator or one accomplice is acceptable, is relevant and entertainable by the court. So this is the third point. Third point is there must be a common intention. When two persons enter into an agreement to commit a crime, there must be common intention. Common intention means what is there in the mind of one conspirator, it also should be there in other, it should be acknowledged by other conspirator. This should be common intention. It should not be similar intention. In Section 34, 149, joint liability and constructive criminality in Indian Penal Code, Mahbub Shah's case, there was the Privy Council coined common intention and similar intention and acquitted some Kashim Shah, one of the accused, in Privy Council final appeal. So what is common intention? What is the similar intention? A wants to kill B. He approaches C or C comes to A. When both assemble together at a particular place, A reveals that A expressed his inclination to kill B. Then C immediately acknowledges it. First accepted, entertained by him. That point only. That is what is called common intention. So A and C go to B's house with common intention to kill B. Suppose A has intention to kill B. C has intention to kill C. But A doesn't know that C is having intention. C doesn't know A is having intention. So A's intention to kill is independent. C's inclination to kill is independent. Those intentions are called similar intentions. So in that process, A has inclination to kill B, C has inclination to kill B, both started going. A already entered into B's house and already killed, but C, having seen that, came back. Yes, I wanted to kill B, somebody killed him on my behalf, I am safe, he comes out. So then C is not liable. So if the similar intention is there, is not admitted, it must be common intention. When once two persons agree together to expressing their willingness to commit some crime, it should be immediately first accepted, acknowledged, or first intention to commit must be entertained. So former intention or subsequent intention, previous narratives cannot be entertained. There is a relevant case is also on this. So this last point is the statement, that is the things or acts said, done, written must be after the time when such intention to conspire was first entertained. This is first. Now this first one is prima facie evidence. Second one is both are conspirators. third one is common intention, fourth one is this first intention already I have explained. So that is for I read out the statement that is the things done, acts done, or words spoken, written, printed, or anything must be after the time when such intention to conspire was first entertained. The first entertained, that is not before the first intention nor after the existence of conspiracy. When once conspiracy is completed, entered, they started it, subsequent intention not allowed, previous intention not allowed. There are relevant cases on this point, dear friends, I will tell you. Now, for first, the first one is there is a case, Ammani and others versus state of Kerala. Ammani and others versus state of Kerala. In this case, accused wanted to give confession against another accused. That means one conspirator, one accused who is caught by police was asked to give evidence in the court. When the accused is questioned, he said that he wanted to give confession. Confession means self-harming statement. What is confession? What is admission? All these things I will take up in. If I say good about me, it is self-serving statement. If I say bad about me, it is self-harming statement. Self-harming statements in civil proceedings are called admissions. Self-harming statements in criminal proceedings are called confession. If accused tells before the judge or magistrate, yes, I have killed that man, that is confession. Suppose in civil litigation, if debtor tells, yes, I have received loan, I borrowed 1 lakh from my creditor, that is admission. So admission. So this is what are the admission, confession, various instances. I will give separate lecture on that point. So here Ammani and so here when accused wanted to, the court said that there should be proved that this accused should establish that there was a conspiracy between this accused and that accused. Both are partners. Then only the confession is there must be a reasonable ground to believe that there is a conspiracy between both of them. He is an accused, that man, both are accused in same particular crime. That is the crime in issue before the court. That is the relevant. That is first point. Second point, one, both are conspirators. Third one, things done. Things, the evidence must be with reference to common intention. With reference to common intention means intention means to desire to commit an act. Common intention means desire of 2 or more persons to do an act, do an act by prior meeting or pre-arranged. Common intention means 2 or more persons making a prior meeting and making a secret planning for commission of an act. So so the when that is called common intention. What is there in one's mind, and the same thing should be there in others' mind, and these two minds should be united to commit the crime. This is what is called common intention. If they commit the crime as per the intention, that is in reference to common intention or in furtherance of common intention. That is the this third point. There is a relevant case on this point. So Emperor versus Ganesh Raghunath Viswapayam. In this case, the word in reference to common intention mean that act intended is in regard to future narratives coming from conspiracy. This also I told you. So what to constitute common intention, it must be within the commission of that common intention. When A and B come together plan together to do a particular crime, within that sphere only the intention must take place, and previous intention or conspiracy is created subsequently, it is done, it is not at all a common intention. So there is one more case, Emperor versus Shafi Ahmad. So in this case, the principle of agency, Emperor versus Safi Ahmad, the court said that in a conspiracy, the conspirators are like mutual agents. In a contract of agency, in contract law, agent is the principal is different, agent is different. For acts of agent, principal is responsible. All civil liability principal will bear. Suppose agent commits crime, principal is not liable. But here in Avatar, in criminal law, Avatar is like a principal, the rowdy shater, principal wrongdoer is like agent. So here in this case, it said, this court said that Emperor versus Safi Ahmad, in a criminal conspiracy, each conspirator, one conspirator is like a principal, and one conspirator is a principal. The relationship of two conspirators is like principal and agent. One conspirator is liable for the acts of another conspirator, is what this court said. But the principal position and the agent position is different. Avatar position and principal wrongdoer position is different. But here the concept of criminal conspiracy is based on implied agency or mutual agency is more appropriate word. Now the most important point with reference to common intention and subsequent acknowledgement of the intention is there. So this is most important case, Mirza Akbar versus the Emperor 1940 Privy Council case. In this case, what happened that Mirza Akbar is the lover, that is accused, main accused. Meher Taja and Ali Askar. Ali Askar and Meher Taja were husband and wife. Ali Askar is husband, Meher Taja is wife. These wife and husband, his wife has extramarital relation with Akbar, Mirza Akbar. Then one day, what they say, they were continuing their extramarital relations. One day, they both think to kill. Ali Askar has become an obstacle for their conjugal relations, extramarital relation. They wanted to get rid of the obstacle, that is Ali Askar. So these two, wife and Mirza Akbar and Ali Askar's wife, they both engaged, and that the adult, the deceased person's wife and her lover both engaged one man, that is called Amar Sher, one rowdy shater. He engaged him to kill him. That man took one gun, a loaded gun, and shot at him, and that Ali Askar died, husband died. Subsequently, after killing, Ali Askar, principal wrongdoer, was running away. He was caught and produced before the court. In fact, these two are avatars. He is the principal wrongdoer. But deceased wife and her lover are the conspirators, and this Amar Sher is the principal wrongdoer. This man, the person, the Amar Sher, who shot him after killing, he started running, and he was caught and produced before the court. Then this conspirator, he gave evidence. No, I have killed him for the reason the deceased wife and her lover engaged me to kill him. Then three were arrested, and the three were arrested and sentenced to death sentence. In the criminal proceeding trial, deceased wife Mahar Taja said, "No, sir, I did not kill him, but my lover, Mirza Akbar, he was threatening me all times. If you don't accept me, if you don't give favor to me, I will kill your husband." As he threatened me to kill my husband, to save my husband only, I had to obey him. Otherwise, still, I tried my level best to avoid him. I asked him not to come, but still, he made such statement to magistrate, magistrate. But there are some love letters were exchanged between this woman and her lover. Those letters were produced, they were accepted as relevant, and basing on that, three were convicted. But during the proceeding, this woman said that no, I did not intentionally did not had extramarital relation with him. He was threatening me to kill my husband. That is why I had to do. Those words which were done, which were told to magistrate after conspiracy were over, were no way entertained by the court. But the prima facie evidence, letters and everything, statement of the conspirator, that is Ali Asgar, who was caught, were taken into consideration and they were convicted. So the statement of woman to magistrate that she is not did not have any inclination to kill her own husband, she had to obey him for the reason that fellow threatened her to kill, was not accepted because the statements were made after the completion of conspiracy. These are the various issues relating to the relating. When after conspiracy is over, if anything is done, they are not allowed under section 10 of the Indian Evidence Act or 8 of the this thing. And finally, there is one more case on this conspiracy. Badri Rai versus State of Bihar is another case. Badri Rai versus State of Bihar is another case. Badri Rai, a owner of a school, his friend, Ramji Sonar, a goldsmith, gold workman, gold ornaments making person on speed. This Badri Rai and Ramji Sonar, these two, he is goldsmith and school owner, both are friends. Once this Ramji Sonar purchased stolen property. When he purchased, it is not purchasing stolen property is an offence under section 410(11) of Indian Penal Code. He purchased. Then this Sonar, Ramji Sonar, was caught by police, and police filed FIR for purchasing this stolen property. The investigation is going on, and this Ramji Sonar approached his friend Badri Rai, a school proprietor. When these two persons are there on the road, the police officer who booked the case was going on the way, and these two accosted that police officer, and you unnecessarily caught him, and you tell something, we will do some favor, we will pay something, you please say that the cost to hush up the case, they wanted to give some amount. I don't like to speak anything, you come to police station, then we can speak, the police officer said. So then the Ramji Sonar friend, that is school proprietor Badri Rai, went to police station. As we discussed yesterday, my friend gave me this packet, newspaper packet containing 500 rupees. In those days, 500 rupees was a very big amount, because the case is on this Ramji Sonar for purchasing gold ornaments and melted silver. So you please hush up this case, and he gave me 500 rupees. That means this Badri Rai and Ramji Sonar committed an act of conspiracy. First case is already there. purchasing stolen property already is there in Ramji Sonar. And one more case on Badri Rai is to instigate a police officer to corruption. That is another case. So that police officer took that packet and seized it and filed FIR and booked the case on both the persons. Both the persons went up to appeal, but it was proved that it is Badri Rai who conspired with Ramji Sonar to make a public servant indulging in crime. So this is what happened in this particular case. Both were convicted for motivating a police officer to do corruption. And finally, restrictions. What are the restrictions? To invoke Section 10 Indian Evidence Act or 10 Bharatiya Shakshya Adhiniyam, the first thing is to when evidence by accused is to be entertained, it must be proved beyond, it should be proved that there is existence of conspiracy. The person who is giving statement and the person against whom the statement is given must be co-conspirators. That is the first condition. Second condition is, if the one conspirator speaks anything, it must be against the interest of the other conspirator or other conspirators. Whatever evidence given by one conspirator doing some favor to other conspirator or conspirator is not relevant and is not allowed. Suppose first, when after giving the statement of conspirator is accepted for the reason there was existence of conspiracy, the other man was a conspirator, and subsequent hearing, subsequent proceedings, the conspirator who gave statement died subsequently, it is immaterial. Still, the statement made earlier by a conspirator who had already dead will be valid and relevant and enforceable. This is the position with reference to criminal conspiracy, dear friend. If you want me, give PDF. I will read out. I will give one more lecture, one more in the sense 1 more hour. I will give heading conspiracy dictation. I will read out that, and if you want, you can write it carefully. You may xerox it, you may type it and circulate it in groups. I have no any objection. If you want that, you tell me over your message. I will tell you in a day or two, within 2 days, I will upload LB section 11 and corresponding section is section 9 in Bharatiya Saksha. Both are same. Up to now, there is no any change. Whatever topics I have covered so far, there is no any change. And if any changes are there, I will tell you. And if you want me, give dictation of this conspiracy, you give your message, then I will read out within 1 hour. You can write it, you put it in a earphone, download it. If you have unlimited net or Wi-Fi, you need not download, directly you do it. If you have limited net, you may download it. You just watch my lectures in earphone only. Don't concentrate on picture because if you hear only audio, it will be more convenient, and at the same time you must be very careful and cautious about English language. That is must. Though you won't be able to speak at present, if you are able to understand English well, if you are able to understand English easily, there is no problem. There is no problem. So first year students, after completing your subjects, you watch other subjects, so that by the time you complete LLB, then when once you complete, by that time, so 200 more lectures will be there. When you have completed the listening of all my lectures, if you remember just 5 to 10 minutes of my 1 hour lecture, your knowledge will be excellent. You will be very, very comfortable in a competitive center to receive anything, to face a preliminary exam, to prepare for an exam. If not selected in the judicial service, you can go to court and become a very good knowledgeable lawyer. You need not be less than anybody prosecuting studies in prestigious law schools. So wish you all success. God bless you. I suggest the students of most prestigious law schools also can watch my lectures and improve their knowledge. Thank you all.